Thank you. Good afternoon, Mr. Chair, members. One of the most sacrosanct relationships in our society is between a patient and their physician. In such a relationship, patients can consult with their physician on private matters about their health and receive a free flow of information and high-quality care tailored to their needs. However, the sharing of patient health information without sufficient physician consultation and privacy protections can have a detrimental effect. This can happen because federal information blocking rules require physicians and other providers to release patient data as soon as available. Thankfully, the federal rules defer to state laws, allowing California the opportunity to balance the goal of providing patient access to information while protecting their privacy and adhering to their wishes. This bill adds new patient protections into California law to ensure patients receive challenging health information in time and manner that works best for them. It also adds new protections for the most sensitive data so that patient privacy is maintained at all times. Testifying in support of this bill is David Ford with the California Medical Association.
Thank you, Senator. Thank you, Mr. Chairman and members. The Senator did a fantastic summary of the issue here. The federal information blocking rules, which were released in 2020 and took effect in 2021, have a very laudable goal, which is making patient data more available to the patients themselves. This allows patients to be more active participants in their own care. However, as the information blocking rules have been implemented in the healthcare marketplace, we've discovered some challenges in the implementation. The unfettered access before the physician has a chance to interpret data sometimes leads to unnecessary challenges for patients, especially if they get information that's not actually bad but looks bad to a layperson. And also we have some challenges in the law in that opening up medical records to the extent that the federal government has potentially challenges patients' right to privacy of that data. Thankfully, we have a section of California code that deals with patient access to health information, but we can make some really minor and clarifying changes to allow us to implement the law in a way that makes sense here in California. Thank you very much.
Do we have witnesses to testify in opposition here?
Good afternoon. My name is Tino Berrigan. I'm here on behalf of A Voice for Choice Advocacy. While we agree with the overall goal of this bill and believe privacy of medical records can never be secure enough, we feel strongly that the records of minors consenting to treatment must be accessible at least at a high level to their parents and guardians so they can assist with their care. This bill would completely remove a parent or guardian's ability to review medical records from any service for which a minor consented. While we understand California has minor consent laws, currently only those medical records relating to mental health treatment may be restricted from parents or guardians, and then only when the health care provider determines that access to the records requested by the representative would have a detrimental effect on the provider's professional relationship with the minor patient or the minor's safety and well-being. SB 1419 would remove this caveat and fully restrict a parent or guardian from being able to review any mental health records. It would also fully restrict a parent or guardian from being able to review any medical records of any sensitive services, including mental health treatment or counseling, drug or alcohol issue-related treatment and counseling, the prevention or treatment of sexually transmitted diseases of a pregnancy, including abortion or for an HIV test, the diagnosis or treatment of an infectious, contagious, communicable disease, treatment due to alleged rape or sexual assault. We want to ensure children are empowered. However, we also want to ensure a strong relationship not only between them and their healthcare providers, but also between them and their parents or guardians who they will be returning home to after treatment is provided. Instead, SB 1419 creates a structure of distrust between the parent, child, and health provider. While we understand some of the areas may be sensitive and minors may not wish for their parents or guardians to have full access to their medical records, there should not be a blanket ban on parents or guardians having access. There may be times where a minor has an adverse reaction to medications, has post-treatment complications, or in rare instances may die while under a physician's care. In these cases, a parent would not be able to access their children's medical records to understand the background and help them. They also wouldn't be able to gain access to file a lawsuit or compensation claim, which a 12-plus-year-old minor would be too young to do. A Voice for Choice strongly opposes this section of the bill relating to minor consent laws. We ask the author and this committee to amend the bill to either fully remove this section or amend it to allow for the minor's representative to access partial medical records, including treatment received, medication administered, adverse events or notable events recorded, as well as full medical records if the child has an adverse reaction or dies while under the healthcare provider's care. We ask you to oppose SB 1419 and not allow it to pass through the Assembly Health Committee unless it is amended as such. Thank you.
Thank you. Please go ahead.
Good afternoon, Chair Wood and members of the Assembly Health Committee. Can you hear me?
Yes.
My name is Bonnie Gale, and I am first and foremost a mother to 5 excellent humans. I'm also a special educator from Amador County and a passionate advocate for parental rights and special education advocacy. I have a son with exceptional needs. As mentioned by the previous witness, SB 1419 would prevent guardians and parents from reviewing all medical records related to medical care consented to by a minor. This creates potential unintended consequences which could lead to delayed treatment of these children if they have severe side effects from medication or treatment. Today, I would like to share with you some real-life scenarios that could result if this bill is passed without amendments to address this section. The first scenario, a 16-year-old minor is at home and starts hemorrhaging. The parent takes her to the emergency room, and the youth admits that she went to Planned Parenthood and got an abortion the day before. Under this bill, the parent would not be able to access the medical records from Planned Parenthood. The doctor would not be able to get the records transferred because the minor child would not be able to give consent to transfer the records, and neither would the parent. Delayed treatment may cause a doctor to be more invasive in their tests and exams because they are not aware of if there were complications during the procedure or what medications were administered. A second scenario, a 14-year-old boy with complex medical history and is on a number of medications to treat various issues. He seeks treatment for the prevention of a STD, and when asked about his medical history, does not have enough knowledge to give accurate information on what his condition is or all the medications he is taking, or however, he is desperate to get the treatment, and so just gives the doctor a partial information, not knowing that the treatment is not recommended for people taking his medication. The parents find him unconscious and take him to the hospital with no knowledge of what he has taken because they do not have access, nor do the doctor can access his medical records. I could go on with several scenarios, but hopefully you understand that this bill as written could seriously harm children if they have post-treatment complications or drug interactions. It would also not allow parents to advocate for their children in the case of an emergency, file lawsuits or complaints on their behalf. Thank you for your time.
Bring it back to the committee for questions or comments. Questions or comments? Mr. Nazarian, excuse me.
Thank you, Mr. Chair. Thank you to the author. Thank you, Senator, for bringing this bill forward as well. But I have to admit to you, I'm somewhat conflicted over this. First of all, in the analysis, a minor who is 12 years of age or older can consent to mental health treatment or counseling services on an outpatient basis in the opinion of the attending professional. Is that a physician, or is it an MFT or an MSW? Do we know for certain who the attending physician is? Attending professional is.
Sure. Let me defer to the witness on.
Sure, it's basically a professional operating within their scope of practice. It's important. So it could be a psychiatrist. It could also be a psychologist. It's also important to note that this existing law. So we're not changing the scope of practice. We're not changing who the attending medical professional could be.
Okay.
And we're also not changing the minor consent rules here.
Okay. Okay, that leaves me a bit more puzzled than I was before, because I thought, wasn't sure if I even read it correctly initially when I read the analysis of attending professional. So I would assume that you would want this to be the physician, and for the physician to have a say in something like this, especially if we're making a decision. I wholeheartedly support anytime there's an incident of rape, sexual trauma, anything of that nature, for the children to be able to protect themselves. But to broaden it to this level, in creating this schism,
Okay, yeah,
I'm
go
just
ahead.
trying to understand why there's a need for this right now.
So I think again, I'll defer on the technical definition of the attending, but the core point that I think the witness was trying to get across is the fact that the bill does not add or create any new law pertaining to sensitive services. That we are simply clarifying this law to make it explicitly clear that clinical notes for minors 12 years of age and older are included in this space. This classification, as we said, is not to undermine parental involvement. Certainly, I believe as two teenagers, I believe that parents are critical in making health decisions. So it's not adding or creating any new law pertaining to those services. It's clarifying that clinical notes are included. And you can answer the other part if you'd like.
Yeah, I was just going to say that there's an existing definition in the Civil Code, in the Confidentiality of Medical Information Act, of sensitive information. We're copying that in the Health and Safety Code. And the reason is because of there's a conflict that's developed because of the federal rules. The federal rules have opened a portion of the medical record to inspection that wasn't open before, called clinical notes. It's the free-form notes that physicians write in the medical record. And because traditionally those weren't available to patients, that's often where very sensitive information is discussed. And oftentimes it's because of referrals that a physician will write things in the free-form notes as a communication to the next physician who sees the patient. But now that the federal rules have opened those up to inspection to parents, caregivers, and others, now we have to create sort of a boot and suspenders protection for those to make sure that we aren't inadvertently compromising the patient's privacy. But as I say, this protection is actually already in the Civil Code. We're copying it over here for consistency of the code and to make sure that the patient's privacy is protected.
Okay, I'm gonna wanna, if you don't mind, I'm gonna wanna see that for myself, and I'm gonna also want to understand why. What I'll get my own research now on this to read up on it, but I'm trying to then understand why do we need to clarify this? Sorry, if it's already in code in the health section, in the civil code section, why does it create a misunderstanding if the federal guidelines have said something, if it's the same language?
So there's three things at play. The federal rule says that the providers must release the clinical notes, okay? But they say based on state privacy law, right? So now we have two parts of state privacy law, the Confidentiality of Medical Information Act in the Civil Code, and patient access to health information, which is in the Health and Safety Code, right? And so as physicians, hospitals, clinics, and other providers are trying to implement this law and implement the federal rules, it becomes a matter of consistency, that we want to make sure that the patient access to health information section of the Health and Safety Code comports with the Confidentiality of Medical Information Act and provides that protection to those sensitive information as is defined on the other side. If you actually look at the original version of the bill, we actually originally had this as just a cross-reference. And in another committee, they asked us to just copy that section into the Health and Safety Code. So that's the bill as it now appears, to provide that protection for teen reproductive health, teen mental health, other things that we provide this protection for in law.
Okay, I guess I need to do my own research right now, but for the purposes also of at least stating my position right now until other questions come up. I don't know if I want to support something like this when just in the past 2 years, we've taken further steps of making sure that just physician, for example, decisions are being questioned at the medical board level in certain cases. And now we're having even a non-physician potentially make a decision that bars the parents from being engaged in that child's health and welfare. So I just that concept also itself is somewhat jarring to me. But that's maybe just me.
Somewhere, if I may. What we're trying to protect here is the physician-patient relationship, right? The patient at any moment, the patient always has the ability to release their own information, right? And so
We're talking about a 12-year-old, right?
yes,
Okay.
in the ideal situation, right? I have 2 teenage children. In that ideal situation, if something's going on with them, they will involve me in their decision making. With all due respect, that's not the situation for every teenager.
I agree.
And so, what
But
this
then
bill,
why not make the bill narrower so that it applies to every case that you and I are sensitive about? But to make it this broad for an age range of individuals who are still very influenced and malleable in how they approach issues, I don't think that helps us in a time where we're constantly trying to protect the family unity, make sure that we're placing our elders in a place of care with the families. When we're taking all these steps to make sure that we involve the family, here's something that's actually, again, shifting away from that. So I'm just not understanding why. If this was narrower, I would support it. But to make it so broad, I question why.
If I can, and the witness can clarify, and I appreciate it, and we can, maybe come back to it. I think this already exists in law. So all we're doing is clarifying the clinical notes part, which have now become newly accessible. So this is really just making explicitly crystal clear about the clinical notes are sort of covered in what is already the law itself. So I don't think it's not going to dramatically affect that relationship. I mean, I think the main point when we really start with the bill, part of the bill is really just about that, making sure that patients get access to the information, they can form a plan with their physician, because we don't want people to get access, say, to results of scans, which now have to be available right away, without having the physician say, hey, let me give you the context on this. This may look bad, but this is not bad. Don't freak out. As we know, people are very sensitive. I certainly would be. So that's really the point, and then we're also, having this clarification around clinical notes. But I would say, I think my team, I know my team did have a good discussion yesterday with the Voice for Choice Advocacy and is sitting down tomorrow with the California Health Coalition Advocacy. So I do appreciate your concern and their concerns, and we are continuing to discuss them.
Thank you. This concern is just me. This is coming. I haven't had a chance to even meet with opposition or anyone on this.
That's right.
So this was just something that I just felt it's broad. So that's it. Thank you, Mr. Chair, for the opportunity.
Of course. Anyone else? Any other questions or comments?
I just
Go ahead.
thank you, Mr. Chair. I do want to agree with my colleague about the issues with that one section, paragraph 4, lines 1 to 6, is where the most egregious part of the bill. I think the part that we're having the most struggle with. When I go to the district, and I've actually thought about ways to improve access to parents for more information, because when I go to the district, and it's happened 3 or 4 times, and it deals with the mental health part of it, they have children and even adult children who go into some type of a mental health treatment, and the parents are not allowed to know what's going on. They don't know where their child is. They can't get to them. They end up, in these specific cases, these people came up to me at different events, not even dealing with mental health. It was just there at a event with the Chamber of Commerce one time. And they said, please do something. My child died, and we didn't know where they were. And there's no information. Yet the parents are responsible for the child. They're responsible for their insurance. They're paying the bills. And it's like they can't get the information. It's just not right. And I can't support the bill with that part of it in it. And I understand what you're trying to do about access between the physician and the patient is important. But we have to also respect, as was said, the family and the parental rights as well. Thank you.
Thank you.
Any other comments? Seeing none, would you like to close, Senator?
Sure. Yeah. Anything urgently you want to say about that? No. Yeah. Again, I appreciate the discussion, and I understand it's focused on that piece, and we do believe that we're trying to make it clear that we are just clarifying that piece about clinical notes. But I understand there's ongoing concerns, and we are continuing to meet with folks on that provision. And with that, I respectfully ask for an aye vote.
Thank you.